My Law is an interactive legal research program that teaches students about the fundamentals of government in preparation to becoming paralegals, lawyers, judges, or civil advocates. The concept of this course is to make citizens aware of the laws that directly or indirectly affect their everyday activities. Within each video lesson, there is included the actual law that is being referenced, so that viewers will have a continuous display of what was enacted. If, after watching this video, you would like to know how you can receive My Law courses in your particular school or organization, please contact us at contact@basescholars.org.
Landlord-tenant issues are one of the most prevalent issues in the United States. Many tenants have one or multiple issues with their landlord, but do not know how to properly address their grievances. Mostly, it is because many tenants do not understand the laws in their particular state. So, today we will attempt to level the playing field by providing updated laws concerning landlord-tenant relations. The laws presented in this episode will only apply to the state of New York. We will cover laws in other states in future episodes. It is important to note that real estate law is quite complex sometimes. So, the majority of concerns may not be resolved after viewing this video. However, this starting point should give you enough confidence to continue research on your own, with the hopes of you finally addressing your grievances. Today we will look at the changes in New York State rent law. Specifically, we will go over the Housing Stability and Tenant Protection Act of 2019. It is important to note that the information presented on your screen is a secondary source of information that references a primary source. When taking your case before a judge, the primary source is the source you will be presenting to support your case. The first section we will look at is new laws protecting all residential renters. Capping security deposits. Landlords can only charge up to 1 month of rent for a security deposit or advance payment. This applies to all residential rentals, with a few exceptions, whether you have a lease or not. This means that if you are moving into an apartment where the rent is $1,500 a month, the most your landlord can charge for a security deposit is $1,500. This also means that your landlord may not charge you in advance for the last month's rent if you are also paying a security deposit. Limiting late payment fees and fees for credit and background checks. A rent payment can only be considered late if it is received more than 5 days after it is due. The most your landlord can charge as a late fee is $50 or 5% of your monthly rent, whichever is less. Before signing a lease, the most a landlord can charge is $20 for a credit and background check. The landlord has to give you a copy of the background/credit check, as well as an invoice from the company that performed it. Otherwise, they can't charge you for it. You can provide your own background and credit check to avoid any fees, as long as the background/credit check was done in the past 30 days. No more tenant blacklists. A landlord cannot deny you an apartment, rental home, or any other type of rental based on a past legal conflict with a landlord. For example, a landlord cannot deny you an apartment because you sued your previous landlord to make repairs. If a landlord rejects your application after using a tenant screening service, a company that landlords use to see if you have ever been taken to court, and you have a past history of tenant-landlord disputes, the law assumes that you were rejected because of this history, and the landlord may have to pay a fine if they cannot give a good reason for denying you. Making it easier to break a lease. If you leave your apartment or other rental home before your lease ends, your landlord has to make a good faith effort to fill the vacancy. If the landlord finds a new tenant, and the new tenant's rent is equal or higher to your rent, your lease is considered terminated and you are no longer liable for the rent. You have a right to a receipt. If you pay rent in cash or money order, your landlord must provide you with a receipt. If you pay rent by check, you may also request a receipt. You only have to ask once. After that, your landlord has to give you a receipt every month. Your landlord must keep proof of cash rent receipts for 3 years. You are entitled to notice of past due rent. Your landlord must send you a written notice by certified mail every time you are more than 5 days late with your rent. If your landlord fails to provide you with a notice, you can raise this as a defense in court. New protections in case of eviction. If you lose a housing case and the judge orders your eviction, you can ask the court for up to 1 year to move if you can show that you cannot find a similar apartment in the same neighborhood. The judge will take into account your health conditions, whether you have children enrolled in school, the hardship on the landlord if you remain, and any other life circumstances that could affect your ability to move. The new law strengthens protections for tenants against retaliatory evictions and increases penalties for landlords who illegally lock tenants out of their homes. Your rights in non-payment evictions. Your landlord cannot bring you to court for non-payment of rent unless they have given you a 14-day written rent demand. Until you are evicted, i.e. the sheriff or marshal executes a warrant of eviction, you can have your non-payment case dismissed if you pay all rent that is owed. In a non-payment case, you can only be evicted for not paying your rent. You cannot be evicted for non-payment of other fees, such as late fees, legal fees, or any other added fee. New protections. For residential renters who do not live in rent-stabilized or rent-controlled housing. Making it easier to get your security deposit back. Your landlord must return your security deposit within 14 days of you moving out. If your landlord takes any money out of the security deposit for damages, they must provide an itemized receipt describing the damage and its cost. If your landlord doesn't give you this receipt within 14 days of moving out, then they must return your entire security deposit, whether there is damage or not. If you are planning to move out, you can ask your landlord to inspect the apartment, or rental home or other type of home rental, before you move. They must allow you to be present during the inspection. At that inspection, the landlord must tell you what needs to be fixed or cleaned. You can then take care of the problems yourself to prevent the landlord from keeping part or all of your security deposit. If your landlord deliberately breaks this law, you may be entitled to up to twice the amount of the security deposit. Better notice of rent increases and lease non-renewals. If you live in an apartment that is not rent-stabilized or controlled, there is still no limit on how much your landlord can increase your rent. However, your landlord must give you advanced written notice before they can raise your rent 5% or more. If your landlord decides not to renew your lease, they must also give you advance written notice. This applies to month-to-month tenants without a lease as well. If you have lived in your apartment 2 years or more, or if you have a 2-year lease, your landlord must provide you with 90 days advance written notice before raising your rent or not renewing your lease. If you have lived in your apartment for more than 1 year, but less than 2 years, your landlord must provide you with 60 days advance notice before raising your rent or not renewing your lease. If you have lived in your apartment for less than 1 year, or have a lease for less than 1 year, your landlord must provide you with 30 days advance notice before raising your rent or not renewing your lease. New protections. For rent-regulated tenants in New York. Rules for major capital improvements, MCI increases. The MCI formula has changed to limit the amount that landlords may collect after performing a major capital improvement. The amount your landlord can raise your rent due to an MCI increase is now capped at 2% of your current rent per year, and there is no retroactive amount. This 2% cap also applies to MCI increases that happened between June 16, 2012 and June 16, 2019, so any rent increase going forward will be limited to 2%. MCI increases cannot be added to your rent if there are any hazardous or immediately hazardous violations at your building. Your landlord must fix these violations before any MCI can be authorized by state regulators. If fewer than 35% of the apartments in your building are rent regulated, the landlord cannot get an MCI increase. MCI increases are now temporary and will be removed from your rent after 30 years. Rules for individual apartment improvements, IAI, increases. Landlords of rent-regulated buildings who make improvements to individual apartments that are vacant or with written approval by the tenant can raise the rent for that apartment, based on how much it costs to make the improvements. This is called an IAI. The new law limits how much your landlord can increase your rent because of an IAI. For buildings with 35 or fewer apartments, the most a landlord can raise the monthly rent due to an IAI is $89.29. In buildings with more than 35 units, the most a landlord can raise the monthly rent due to an IAI is $83.33. Before a landlord can collect a rent increase due to an IAI, they must first fix any hazardous or immediately hazardous violations in the apartment. The landlord must use licensed contractors to perform any work it intends to count as an IAI. A landlord can only claim up to 3 IAIs in a 15-year period. IAIs will be removed from your rent after 30 years. Protections for preferential rents. If you are paying a preferential rent, your landlord is no longer allowed to revoke it and raise your rent to the higher legal regulated rent. If you have a preferential rent, it will say so on your lease or on a lease rider. The lease will show your legal rent, and if you have a preferential rent, it will be shown in the section of the lease that says, lower rent to be charged, if any. This means that your landlord cannot raise your preferential rent more than the percentage set by the Rent Guidelines Board, plus any charges for MCI or IAI, if they apply. No more vacancy increases. Vacancy bonuses and longevity bonuses are now prohibited. The vacancy bonus allowed landlords to increase the rent of an apartment up to 20% once it became vacant. The longevity bonus allowed landlords to increase the rent if the previous tenant had been living in the apartment for 8 years or more. Curbing the deregulation of apartments. In most cases, landlords are no longer allowed to take an apartment out of rent regulation when the rent is more than the high rent threshold and the apartment becomes vacant. In most cases, landlords may no longer take an apartment out of rent regulation if the tenant is considered high income. Apartments that were deregulated before June 15, 2019 will continue to be so. However, you should check your rent history, as the law now allows you to look back at your apartment's rent history to challenge both the deregulation of your apartment and the rent you are being charged. We will continue discussing landlord-tenant relations in the next episode. When we return, we will continue learning about the Articles of the United States Constitution. Article 2 of the Constitution focuses on the executive branch of the United States. There are 4 sections in this article. Section 1 has 8 clauses which focuses on the powers, requirements and compensation of the President. The first clause states that executive power shall be granted to the President shall hold office during a term of 4 years and the Vice President shall hold such term with him. The second clause states that each state shall appoint a number of electors, equal to the number of senators and representatives in Congress, with senators and representatives being forbidden to be an elector. The third clause, which gives specifics about the electors, has been superseded by the 12th Amendment, which we will focus on in a later lesson. The fourth clause gives Congress the power to determine the time to choose the electors. The fifth clause expresses the requirements for holding office of the presidency. Such person must be a natural-born citizen, or citizen of the United States, be 30 years of age or older, and 14 years a resident within the United States. The sixth clause focuses on the inability of the president to continue in office. This clause has been affected by the 20th and 25th Amendments. However, a chain of command is given as to who fills the duty of the president if the current president is incapable. The seventh clause expresses that the president shall receive a compensation during his term in office, which shall neither increase nor decrease within that period. And, the eighth clause is the oath or affirmation the president must recite before being granted to hold office. Section 2 focuses on the president's power over the armed forces. There are 4 clauses in this section. The first clause expressly states that the president is the commander-in-chief of the Army and Navy, and of the militia of the states during wartime. He, also, has the power to grant reprieves and pardons for offenses committed against the United States. The second clause gives President power to make treaties, nominate and appoint ambassadors, consuls, judges and all other officers. However, this power is limited to the advice and consent of the Senate. The third clause gives the President the power to fill vacancies during the recess of the Senate. Section 3 focuses on the President's duty to, periodically, convene, or speak with, Congress on matters that pertain to the United States. This is known as the State of the Union. Section 4 explains how the President, Vice President and all civil officers can be removed from office. The current cabinet of the executive branch includes the Vice President and the heads of 15 executive departments. For more information about the executive branch, visit www.whitehouse.gov.
Can you clean my garage? Can you steam my carpets? Can you work really fast? Do you provide your own cleaning supplies? Can you work around my schedule? Do you screen your workers? Can you clean my business too? Okay, I don't need my husband anymore.
Article 3's focus is the judicial branch. There are 3 sections in this article that expresses the powers of the courts. Section 1 states that the judicial power of the United States is given to one Supreme Court, and such inferior courts as Congress may, from time to time, establish. And, the judges shall receive a compensation, which shall not be diminished, or decreased, while they are in office. Section 2 focuses on the judicial powers of the courts. This section has 3 clauses. In the first clause, power is given to the courts to hear cases that are constitutional, cases that have been affected by the laws of Congress and any treaties made, cases between 2 or more states, cases between citizens of different states, and cases where citizens of one state has an issue with the government of another state. The second clause states that the Supreme Court shall have original jurisdiction over cases involving ambassadors, other public ministers and consuls, and those in which a state shall be a party. The third clause states that the trial of all crimes, except impeachment, shall be by jury. And, the trial shall be held in the state where the offense was committed. Section 3 focuses on the greater offenses against the United States and the punishment. There are 2 clauses in this section. The first clause defines treason, which is warring against the United States or giving aid or comfort to the enemies of the United States. No person shall be convicted of treason unless on the testimony of 2 witnesses to the same overt act, or on confession in open court. The second clause gives Congress the power to declare the punishment of treason. Article 4 of the Constitution focuses on states' relations. There are 4 sections in this article. Section 1 states that full faith and credit shall be given in each state to the public arts, records, and judicial proceedings of every other state. Section 2 has 3 clauses. The first clause states that the citizens of each state shall be entitled to all privileges and immunities of citizens in the several states. The second clause states that any person charged in any state with any crime, who shall flee from justice, shall be brought back to the state which has original jurisdiction of the crime. The third clause has been effected by Amendment 13 of the Constitution, which we shall explore in a later lesson. Section 3 has 2 clauses. The first clause states that new states may be added to the Union. However, no state shall be formed within another state, and 2 states cannot form together, unless approved by the legislators of the states and Congress. The second clause states the Congress shall have power to dispose of and make all needful rules and regulations respecting the territory or other property belonging to the United States. Section 4 states that the United States shall guarantee to every state in this Union a republican form of government.
I've had this problem.
Big problem.
I really needed.
A good housekeeper.
And I kept searching.
And searching.
There are so many choices.
It's really hard to find one that has all the things on my list.
But I finally did it.
Yes, yes, yes. Thank you.
If you were looking for one as well,
Look no further.
Here's a really good one.
Just use mine.
Use mine.
I'm very satisfied.
Definitely recommend.
Problem gone.
thank you.
To find the area of a triangle, simply multiply half of the base times the height. For example, this triangle has a base of 4 and the height of 6. To find the area, simply take half of 4, which is 2, and multiply it by 6, which will give us a total area of 12. Second example. This triangle has a base of 10 and a height of 12. To find the area, simply take half of 10, which is 5, and multiply it by 12, which will give us a total area of 60. Final example, this triangle has a base of 15 and a height of 8. To find the area, simply take half of 15, which is 7.5, and multiply it by 8, which will give us a total area of 60. Almost always you will have to express your answer using some type of unit, such as feet, centimeters, inches, etc. To express your answers using any one of these units is easy. Example, our previous triangle, which has a base of 15 feet